I just moved to Florida, Attorney Jacobs. I have a couple of minor children. We had a final judgment and a parenting plan in Virginia, and now I want to make sure that is enforced in Florida. Enforcement in Florida might be able to be done in certain aspects of child support, for example. But if you're looking to domesticate, and this particular podcast episode is about domestication or registration of a child custody determination, then there are some rules you need to know. For starters, if you're seeking to domesticate a foreign judgment from another state, by foreign, we do not mean from Mexico, China, Argentina, Saudi Arabia, Israel, India. We mean from another state within the United States where there's previously jurisdiction over your case and now you live in Florida. Well, keep in mind a few basic prerequisites. One is that both parties have to have moved from the home state where that final judgment, parenting plan, marital settlement agreement was originally issued, ratified, adopted, affirmed, ordered by the court. If one party still remains there, even if you live here in Florida with your minor child, it is likely that that home state will retain jurisdiction over all issues, perhaps with the exception of child support if you've moved, that involve your case, your finances, your child custody arrangement and situation. If both parties have moved and there may be some military issues going on, if the individual still retains residency and jurisdiction in the home state, but may have been deployed for a period of time, separate issue, but it may impact this entire thing. When you domesticate, both parties must have moved. And specifically, if this involves minor children and you live in Florida, then your children should have lived here for at least 6 months for the child custody jurisdiction to take effect via the UCCJEA and Florida courts. Now, why would you want to domesticate a petition? I'm sorry, rather, why would you want to domesticate your final judgment? One reason is that you live here in Florida now. And if there's an issue with parenting, you do not want to have to go to Virginia, California, Texas, or Wyoming every single time for an enforcement. Not all courts offer virtual appearances. Not all courts offer you the opportunity to appear by Zoom, Teams, WebEx, FaceTime. Some courts require you to appear in their courtroom. And if that courtroom is in a very far away jurisdiction and you have lots of problems with your former spouse or former partner, then you are not going to want to travel every single time. If you live here in Florida with your minor child, you do not want to have to go every month or two to a foreign jurisdiction, spend the money on travel expenses, spend the money on court expenses to go there, hotel expenses, and what have you to litigate the issue each and every time. Even if they did offer virtual appearances, if you live here in Florida now, then you want that quote home state advantage. You want that. So the other party is going to have to appear remotely here in Florida, or the other party is going to have to travel here to Florida. You want that home turf advantage, whether it exists psychologically or in fact may depend on your situation, the county your case is litigated in, et cetera, et cetera. Further, if you live here in Florida now and you have minor children and the other party is paying child support, well, you might want the Florida court to enforce that. Now, logically, if the other party lives in the home state, which they can't for this, or a surrounding state rather, if the other party lives in a surrounding state, you're going to want Florida courts to enforce it, or you want it to be enforced in a foreign state through the Department of Revenue in that particular state. Great question. There's no obvious answer because you do not know if that other state's enforcement mechanisms are punitive, are harsh, are effective, if they can find the other person who's not paying child support, if they're going to follow through. And somehow, if that money is then going to be sent to the state of Florida disbursement unit and then ultimately sent to you, if maybe it's sent directly from that other state's DOR, might the other state say, hey, you're not a resident of the state and you're seeking support, so Florida has to do it? All of those are possibilities. What we do know is that for all of its misgivings, like any other agency, the Florida Department of Revenue does a pretty good job of chasing people down when they owe child support and of enforcing it. And I go back to this, if you want to enforce something, it makes logical sense to enforce it 15 minutes away from your house than it does 1,500 miles from your house. Domestication is hyper technical, not particularly easy. It relies on multiple Florida statutes, and not every judge and not every court is intimately familiar with this. It can be confusing. And if it's confusing, that means your counsel has to have the wherewithal and the knowledge to make sure that we know exactly how to handle the situation and exactly what to do because every step of your case is going to be complicated.